In Faretta versus California, the United States Supreme Court held that a criminal defendant has a Sixth Amendment right to conduct his or her own defense if the defendant voluntarily and knowingly waives the right to counsel. But courts can still appoint standby counsel to assist pro se defendants, or defendants who choose to represent themselves. In McKaskle versus Wiggins, the court explored the appropriate role of standby counsel. After pro se defendant Carl Wiggins was convicted of robbery, he received a new trial due to a procedural defect. Prior to the second trial, the court appointed 2 attorneys at Wiggins's request. But Wiggins routinely changed his mind about counsel's role. He repeatedly stated a desire to defend himself and asked the judge to prevent counsel from interfering. But during trial, Wiggins consulted with the attorneys and agreed to allow them to perform certain tasks. Wiggins's inconsistent attitude also appeared in proceedings outside the jury's presence. In front of the judge, the attorneys frequently disagreed with Wiggins's approach and filed motions, raised objections, and suggested actions Wiggins should have taken. Wiggins sometimes opposed, but other times adopted the attorney's efforts as his own. Wiggins was ultimately convicted and sentenced to life in prison. He subsequently filed a petition for habeas corpus in federal court to challenge the validity of his conviction and detention. He argued that the standby counsel improperly interfered with his Sixth Amendment right to conduct his own defense. The district court denied Wiggins's petition, but the Fifth Circuit reversed, holding that standby counsel's instances of unsolicited participation violated the Sixth Amendment. The United States Supreme Court granted cert.